Welcome to INAN's Advocate. INAN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Preshita Mohan Parab. She has graduated her bachelor's in arts from University of Mumbai in the year 2020. She has graduated her law from the University of Mumbai in 2023, and she is currently pursuing her master's in law from KC Law College, and she exclusively practices in criminal law. Today, she is going to speak on POCSO Act in action. So without wasting further time, I would request Advocate Preshita to commence with her lecture. Thank you.
Hello everyone. So let me start my lecture by saying who is the most vulnerable in the society? So the one who can't express themselves, who can't see what they're feeling or what they're going through. So this is all about the POCSO Act in short. Why it was enacted, how it came into legislation, and what are the important sections into it, and what is the current status of POCSO Act is all that I'm going to describe. So first, I would like to start with my introduction. Imagine a world where every child grow up free from fear, they can play, they can thrive without the shadow of abuse looming over them. You know, it do happen that every time in the society when my little cousin or my sibling goes downstairs and I say that, oh, be little cautious. If anyone asks you about a little chocolate, don't take it from there. Because we always fear that someone will cause a harm to her or will abuse her sexually, whether it is a boy or a girl. And hence, there was a necessity to form such a stringent law that would protect these children from vulnerables. So the recent report which I got from our website or from the Google was of the National Crime Records Bureau. The report is from 2020 to 2021. So you can see there has been increase of 16.2% in the crime against India. So the total rate of crime if we take against the children in India was 19,055 cases were recorded. This was in 2021, which show an increase of registration in 26.7% than that of 2020. Now let us take that how the states have been bifurcated with as likely like how much crimes have been conducted in that particular state. So the first one where the majority cases of crime against children were reported was in the Uttar Pradesh, second comes Maharashtra, and the third comes the Kerala. Now further, the punishment under the POCSO Act are very stringent. So our legislatures have made this provision so stringent that no one can get out the clutches of this act. But what happens is every coin has its two sides. So when a legislation is made so stringent, there are also the chances that it may be misused. And that is what is happening currently in India. This law has been misused by many people, taken in the matrimonial dispute, in the inherent acts or inherent cases and other cases as well. It can be so minor that it could raise out of a small dispute in a locality, and that could result into many false and ferocious POCSO acts. Now, let us start with the history of the POCSO Act. Why POCSO Act? There was IPC, CRPC into law, which was already dealing with the various kinds of offences against the women and children. Then why particularly POCSO Act? Now see guys, if we look about the equality, we have to always give a priority to those who are more vulnerable. We have to support them. For example, if you're having one block, you're standing on just one block, then for vulnerables, we need to give them a 2 blocks. And that's how the POCSO Act came into force. So basically, the POCSO Act was made with the mere intention to focus and to make more stringent law for the children who are already facing so much, because they are the vulnerables and they cannot speak. And hence, to focus and make more stringent law to protect these children and give a better future for these children in our country, this POCSO Act came into regulation. Now I'm going to go to the POCSO Act in brief. However, I'm not going to touch upon all the 46 sections which are there in the Act. I'm just going to highlight the important sections so that the people know that what does the POCSO Act was really into. So now the POCSO Act consists of 9 different chapters. Now this 9 chapters we basically divide into 3 types, okay. So first is the sexual assault, then is the sexual harassment, and then comes the child in pornography. Now sexual assault. Sexual assault is divided again into two parts, that is a penetrative sexual assault and second is the aggravative penetrative sexual assault. Which is the penetrative sexual assault is defined under section 3 and 4, whereas the aggravated penetrative sexual assault is defined under section 5 and 6. Now let us talk about what is sexual assault. Now this term sexual assault is defined under section 5. Now what is a sexual assault? Sexual assault is basically when you have a physical contact with any of the child on any of its private parts, or you ask that child to touch any other person's private parts or lead into a physical contact that results into a sexual assault. Simple. Now let us take an example. For example, my child is going into a bus. The bus is very crowded. Now the person behind him is trying to push her. She's trying to move herself out of that, but that person keeps on pushing her. Then he places his hand on her breast, flowing her. Then what does she do? She tries to shout. Then the people ask her, what happened? But still that person says that no, I have done nothing. But that is a sexual assault, and that could be reported under section 5, and the punishment is under section 6, which is under section 7 she can report the sexual assault, and under section 8 the imprisonment is for 3 to 5 years and may include a fine. Now you may say that, it was such a small thing, but this is the beauty of POCSO Act, that it protects the vulnerables and the imprisonment is given so that this mistake is not repeated by any of the offender again. Second, we come to the aggravated sexual assault. Okay, now this applies to assault committed by the specific individual such as police officer or public servants. Now you can see that sexual assault is particularly for the citizens, whereas the aggravated sexual assault is specifically made for the government servants or for the police officials who are there to protect us. If these people are not protecting us or taking the undue advantage of the power which are given to them, then it would certainly result to aggravated sexual assault. So aggravated sexual assault is defined under section 10, and the punishment is so that imprisonment to 5 to 7 years, just to make it stringent, and it may also lead to a fine. So next we come to penetrative sexual assault. As we said earlier, under section 3, the penetrative sexual assault is defined. Now this section involves various forms of penetration of a child's body. The references are clearly given into the Act. You can also refer to the various kinds of penetration which have been defined in the Act. There could be a variety of penetration. If there is any kind of penetration, it not be limited only to the private parts, but any kind of penetration which is found in the body of the victim could lead to a penetrative sexual assault. Okay, now the punishment of this section is given under section 4, which is minimum 10 years and life imprisonment for penetrative sexual assault. However, when the penetrative sexual assault is for a children who is below the age of 16 years, okay, so the POCSO Act is specifically for the children up to the age of 18 years, but when a penetrative sexual assault is done on a child who is below the age of 16 years, then the punishment increases, and the punishment increases to minimum of 20 years, potentially exceeding to life imprisonment. Fine must be imposed reasonably for the rehabilitation of that little victim girl or a boy. Now this POCSO Act is not a gender specific act and could be referenced to any of the gender. So this is a gender neutral act which has come into existence. Why? Because IPC under section 376, it was particularly for a woman. The victim could only be a woman, but in POCSO it is not specific only to a woman, but it could also be a man. Next we come to aggravated penetrative sexual assault. Now how you will refer this aggravated sexual assault? For the government servants and police. So hence the aggravated penetrative sexual assault will also be for the police persons or the civil servants or the government staff. Okay, so the section 5 of the POCSO Act identifies circumstances under which a penetrative sexual assault is classified as aggravated. Why is it aggravated? This include offences committed against the children by police officer near police station, armed forces near the jurisdiction. Now who are these armed forces? Army, Navy, Air Force. Clear? Then we come to the public servants or the staff from jail, hospital or educational institution. Now you say, how come the staff from jail? Now it does happen sometimes that the ladies who are there in the jail, they tend to give birth to a child in a jail. and sometimes the children also resides with their mother for their motherly care. So at that duration also, if any of the jail staff takes an undue advantage of their power and do any kind of act which results into a penetrative aggravated sexual assault to a small child from that jail, then it would lead to an offence under this act under section 5. So now such actions, which actions? Which is the aggravated penetrative sexual assault by the police officers, armed forces, public servants or staff would result into a punishment which is defined under section 6 of the POCSO Act, which mandates imprisonment of 20 years and potentially exceeding to life imprisonment. Can you see the difference? If we see the sexual assault is always having a lesser punishment than the aggravated. Okay, aggravated will always have a maximum amount of the punishment so that the act is made stringent and the offence is not repeated by the offenders. Okay, so it ranges to a life imprisonment and or there is also a condition that meaning the remainder of the offender's natural life and may include fine or even a death penalty. So basically, how are this punishment divided? It basically depends upon the circumstances, upon how grave the injuries were and in what situation it did occur. Next, we have the sexual harassment. Now, sexual harassment is clearly defined under section 11. Now, I am just making it simple. These are not the wordings of the act itself, but just to make it simpler, I am just putting it has been bifurcated into various segments as to how the sexual harassment could happen. So, first of all, we will be making it as making sexual remarks, sound or displaying any objects with sexual intent to a child, or coercing a child to expose their body to the offender or others. Secondly, showing a child any pornographic material. Secondly, stalking or watching a child whether in person or online. Threatening to use real or fabricated images of a child in a sexual content through various media. Enticing a child through pornographic purposes. And now the punishment for this particular section 11 has been defined under section 12, that is punishment of a child can be up to 3 years of imprisonment and may include a fine. Now, you can see clearly that the offence are not only limited to having a particular sexual assault, but it also includes various kinds of things which could impact a brain or a child with regards to sexual activities. For example, exposing a child or stalking, which could make a child uncomfortable. And generally what happens, a child is not very known to such things like what is a wrong touch or a bad touch or what is happening, what is not happening. But if they express to you that no, that particular person has been watching me over for so many days, has been following me, then also it would lead to a sexual harassment. Next we come to using of a child pornography. Now, pornography has been readily available to all the people nowadays due to the OTT platform. There is no age bar for any people to watch this contents. So, child pornography has become a major issue in today's digitalized world. So, now the section 13 of the POCSO Act states that section 13 criminalizes the use of child for a pornographic purposes. Now, what does this mean by pornographic purposes? It includes representing a child's sexual organs, involving a child in real or a simulated sexual assault. Even the morphed photographs of a child would only be will also be considered into this section, or displaying a child in an indecent manner in a media. Offender faces a penalty under section 14 and 15. So 13 describes using a child in a pornographic image, and 14 and 15 define its punishment. So section 14 prescribes a minimum 5 years of punishment and fine and fine. But whereas if the offences of the offender is in continuing nature, which means if the offender is a habitual offender, then the punishment certainly increases and it goes up to 7 years. So for first offender it is 5 years, and for repeated offender it is 7 years. Whereas section 15 addresses the possession or storage of the pornographic material involving children. For example, if you are in possession of any of the content which are readily available on media which involves a child pornographic video, then you would be punished with a fine which is starting at 5,000 rupees, and for habitual offenders it becomes 10,000 rupees. So now storing or possession of a child pornography for distribution, okay, except for reporting purposes, can lead to imprisonment up to 3 years or both. Now for example, there are various people who are engaged in this business of distributing or circulating the pornographic image of children, and they do make money of it. However, it is an offense. Okay, you might get imprisoned for 3 years. However, just look at the beauty of this legislation, because it has clearly stated that except for reporting purpose. For example, in POCSO Act, if a complainant gets to know that this person is involved in the distribution of the pornographic image, and if he wants to file an FIR in the form of an evidences, then in that case this section will not be applied to that particular person, or he would not be arranged as an accused under this particular section. Whereas commercial possession, what does commercial possession means? For making money. For making money, if a person is using such kind of act or is distributing the pornographic image of a child, then he, for the first conviction, he would result into a punishment, imprisonment of starting 3 to 5 years, and then if he is a habitual offender, then from 5 to 7 years. Now next we will come at abatement of child sexual abuse. Now let me tell you a story. There was one particular case in which not only the husband but his wife was also involved in helping him to conduct a sexual activity with a victim girl. Sounds ridiculous, right? How can a woman help? But this POCSO Act also includes a punishment for women. If she is abating into it, or any person who knows that this sexual assault is against the will of that little victim, take it as that in POCSO Act the consent is not mandated, but still if you see that the little child is getting harassed or is going through a sexual assault and still you are helping it, then also you will be punished under this act. And this is under section 16, which clearly outlines what is the abatement of sexual assault under the POCSO Act. So it includes instigating someone to commit an offense. Secondly, conspiring with others to commit an illegal act. As I told you an example, like there is a husband who is committing a sexual assault and there is a wife who is assisting him to commit a particular sexual assault. Then also it will be reported under section 16, which is abatement. Secondly, intentionally aiding the commission of the offense. You know that is a wrong, but still you are intentionally helping him. Why? It may be due to you have some grudges against that particular person or anything as such. But still you are assisting it, then also you will be an offender under section 16 of the POCSO Act. Okay, and what will be the punishment? The punishment is aligned under section 17 and it sets some penalties under the POCSO Act. Next, attempt to sexual abuse. Okay, now firstly, not only you have committed a sexual abuse, but you have attempted to commit, and that victim has left from the clutches or has been loosed from the clutches, from your clutches, but still you will be held liable under section 18 because you have made an attempt of child sexual abuse. Now section 18 of the POCSO Act states that attempting to commit an offense under this act is itself an offense, punishable by 2 options. First is imprisonment up to half of the sentence for life with or without the fine, and secondly imprisonment for up to half of the longest terms of that offense, also with or without fine. Now the major question comes that it's okay, we have made an provision for POCSO Act, but our courts are so much crowded with other matters. How will the trial of this particular section, which is so stringent and which is so necessary for the children, will happen? So the trial of the POCSO of the cases under the POCSO Act, so the chapter 7 says that you have to establish a special courts which will only look after the matters which are related to the children, to the victim children under the POCSO Act. Now which will this be, which all courts will be the special courts? So this will be the sessions court of the particular district. Now under section 28, this mandates that the sessions court be designated as a special courts by the state government in consultation with the Chief Justice of High Court, allowing them to handle the cases related to the child sexual abuse and publication of sexually explicit material involving the children. So basically only the session courts which have been authorized by the state government in consultation with the Chief Justice of that particular High Court will have the authority to conduct the trials or to look after the cases related to protection of children under the Sexual Offences Act 2012. Now next, we will come to the timelines under the POCSO Act. Now, this is a particular act in which a specific timeline has been given even for conducting the trial of that particular case, so that the justice is delivered expeditiously and so that the child is not suffered because of this particular, just because that person does not have to come again and again. If he is left on a bail out, then the offender and the victim will see each other and the victim will suffer more harm. So hence, we say that under section 35 of the Act, specific guidelines have been given for the timelines of proceedings. So the first, the child evidence must be recorded within 30 days of taking the cognizance of the particular act. Secondly, the trial must be concluded the trial must be completed within 1 year of the acknowledgement of such a case. Now, there are two beautiful cases which definitely tells about the timeline, and second tells us how is it not possible to complete that whole trial in 1 year, because the sessions court are not specifically allotted with the POCSO Act matters, but they also have different other matters, and there are also different kinds of application which are coming every day which they need to handle. Also, there is a problem with regards to the evidences or the witnesses which are coming to the court to provide them with a proper assistance and then recording their cross chief. Then there is also a lacuna in the technicalities which still date we are facing in the courts. However, we are trying to improve it, but I will just focus on these two cases. First is of Shubham Vilas Taide versus State of Maharashtra, in which the special court allowed the evidence recording after the 30-day period which was contested, but ultimately upheld by the Bombay High Court, emphasizing that the court can proceed beyond this timeline as long as the reason for the delay is documented. So first of all, within 30 days of period, recording the evidence is generally not possible, because I already told that the courts are already overburdened by their work, and hence, considering this timeline which is provided under section 35 of the POCSO Act, they had went to this, they have upheld this decision in the Bombay High Court, that how will we complete this in 30 days. So Bombay High Court has clearly stated that if you are providing a reasonable reason that why the evidence has not been recorded into the 30 days, then that leeway can be given. Secondly, we have the Alok Srivastav versus Union of India and others. The case is of 2018. Herein, the Supreme Court of India set guidelines for special courts under POCSO Act 2012 to ensure trials are completed within 1 year. High courts must ensure that the cases are heard by trained judges and special courts if needed. This court should minimize adjournment and follow the Act procedure to meet the deadlines. Secondly, the Chief Justice are to form oversight panels and special task force will manage investigation and witness appearances. Additionally, the High Court should create a child-friendly environment in this court to uphold the Act spirit. Now, as I told you that, what were the basic problems that we were facing with regards to completing the trial within the 1 year? It was basically that we did not have the proper sources, the judges were overburdened with the work, or they were not specialized judges, and there were too much of adjournments and delay in bringing the witnesses or evidence before the court. So the Supreme Court has very clearly in this judgment in 2018, which is just if we take it as 6 years after the enforcement of this legislation, that is the Prevention of Children from Sexual Offences Act, they've clearly stated that how can you complete the complete trial in 1 year if we follow such kind of steps. However, the implementation still remains a question. Next we come medical examination. When it comes to a victim of rape or sexual abuse or sexual harassment, the main evidence which remains before the court is the medical examination. It might be a hymen rupture, there might be an injuries, or there might be any kind of stain marks or any kind of abrasion which is found in the body of the victim, which would really help us to know as to whether the act has really been committed or not committed. However, the problem always remains is that the delay in filing the FIR. So the medical examination of the child must be handled with great care under the POCSO Act. According to the Rule 5.3 of the POCSO rules, no medical facility of practitioners should require a legal documentation before providing any kind of medical assistance to a victim under the POCSO Act. Now, Section 27 of the POCSO Act specifies that the medical practitioners must follow section 164A of the criminal procedure code. Secondly, it should be the medical practitioner who will be examining a female victim along with another female practitioners who is authorized or appointed by the medical institution for that particular work. Now, the overall act was to make it a child-friendly investigation and a trial. I said you that if the victim and the offender sees each other again and again after the commission of the offence, or after he has been arraigned and accused in that particular offence and he has been bailed, then it would cause a more harm to the mental status of that little victim girl or a boy. So the whole act was enacted with a mere motive to keep it a child-friendly investigation and trial. So let us see the section 24, 26 and 33 of the POCSO Act, which outlines a procedure that prioritizes that the child needs a child's need during the investigation and the trial of the POCSO under the POCSO Act. So including that the child's statement should be taken at a home or at the place of its comfort. Secondly, the person who is taking the statement of the child should not be in uniform, so that the child is not afraid and he is very calm and relaxed while giving his or her statement. Secondly, the child should not see the accused during the entire process. Secondly, child cannot be detained in the police station at night. Thirdly, the child's identity must be protected. Now, this is a very stringent thing which also came up during, it is not related to the POCSO but also in the rape victim, which is the Kolkata case which we have recently seen. And the Chief Justice of India had also made a very stringent statement that the victim's identity, which has been published on any of the social media platforms, on any of the print media, should be removed, so that we let the victim live in a dignity and her identity is also protected. The same thing is also reiterated and made stringent in the POCSO Act, that the victim's name is never and never reiterated anywhere or brought into the picture. Secondly, the statement should be recorded in the presence of someone that child trusts using audiovisual methods if necessary. It is a very common practice that while recording the 164 statement of the victim in the magistrate's court, that she is supported or assisted by her parent or by any of her guardian or any of the person with whom she is comfortable, so that she can give her statement very clearly and she is held by the person during her statement. Okay? Then we come that the trial should allow breaks and should avoid a repetitive questioning. Cross-examination. So cross-examination is basically a very tedious task because the victim has to go by several questions into it. So they should give them a break and should give them a relaxed time in which they can think and then answer the questions. Then we have aggressive questioning is not permitted when it comes to a small victim under the POCSO Act. Next we have the last scene theory. Now this last scene theory is basically used or presumed under the POCSO Act. So what is a last scene theory? So last scene theory is basically like, I'll just make it into Hindi so that you guys could understand it in a better way. अगर उस आदमी को वो विक्टिम के साथ उस समय उस विक्टिम ने उसको लास्ट टाइम देखा होगा और जो एक्ट हुआ है और जो लास्ट सीन है उसके बीच में का जो डिफरेंस है वो बहुत कम है, then we will presume that this person is a culprit in that given act. This is the presumption which was basically used under the POCSO Act. So this is known as the last scene theory. Reiterating his wording is that last scene theory in child sexual abuse case assumes that a person last seen with the victim is likely the perpetrator, provided the gap between the last scene and the given act. Okay. Now, Supreme Court has given a very good judgment that this in Shamal Ghosh versus State of West Bengal, stating that the assumption is reasonable if the time gap is insufficient. फॉर एग्जाम्पल वो बच्चे ने उसको देखा है कुछ आधे घंटे 2-3 घंटे बाद में, ठीक है, ये लास्ट सीन उसका वो है और उसका एक्ट कुछ हुआ है परसों के दिन में, तो ये थोड़ी लाई करेगी क्या, उसके बीच में बच्चे ने किसी और को देखा रहेगा, तो ये जो लास्ट सीन थ्योरी है वो रीजनेबल नहीं हो सकती है एंड उसके ऊपर से हम लोग एक इंसान को कल्प्रिट घोषित नहीं कर सकते. There should be an evidences, there should be a circumstance, there should be a chain of evidence which proves the culpability of a particular offender. Next, we come under the presumption of POCSO Act. So this is under section 29 and 30, which creates a reverse onus. So the provision shifting the burden of proof of to the accused for certain offences. Now section 29 requires the court to presume that the accused has committed, abetted or attempted the offence they are charged with. Second, section 30 mandates that the court offences that they presume that the existence of accused culpable mental state, specifically sexual intent, in cases under section 7 and 11. Okay, so this is a assumption of rebuttal, means that the accused can provide evidence to prove they lack the required mental state. Now imagine a person has been made to stand before a sessions court, and the court has to already presume that this person is culpable, he has this kind of sexual intent and he was present at the site, he has abated or attempted or committed that particular offence. Now the rebuttal option is only on the offender to prove that he has a particular evidences to prove that he has not done that particular act, or there is a lack of evidence to prove his culpability. So this onus or this reverse onus was something which is against the fundamental right of a person, because the session court judge or the particular magistrate or judge has to already keep it in mind that this person is a culpable under this given act. Next, we come on to the critics of section 29 and 30. So as I said, that burden of proof is placed on the accused must adhere to the under the fundamental rights, which is under article 40 and 21. Okay, and then we come that section 30 mandate that the presume a culpable mind state based solely on the charges, disregard that the legal principle that such inference should stem from the proven fact, undermining the fairness of judicial process. For example, based on the evidences, if you are going to take into the mind that he is a culpable offender, then it is fine. However, just that person standing or he has been caught into that offence, and if you are still considering him as liable for that act, then that is a wrong thing and that is against the fundamental principles of our constitution. Secondly, we come to the compensation under the POCSO Act. Now this POCSO Act specifically regulates on the betterment or to the rehabilitation of the compensation for the victims under the POCSO Act. So the compensation under the POCSO Act is given in such a manner that the victim is given a partial or an intermediate compensation at the initial stage when the FIR is lodged. Only the thing is that the victim or the complainant or the guardian of the victim has to make has to give a letter or an intimation that they need a intermediary compensation for any kind of purpose they require. Okay, so the rule 7 under section 33(8) of the POCSO Act addresses the compensation. Okay, it states that the special court may direct a compensation to the victim. Now rule 7 of the Protection of Children from Sexual Offences Act rules, okay, from the rules 2012 provides a detailed provision for victim compensation. So the first one is the interim compensation. I said you that they give a small compensation at the very initiation of the FIR, and the later half is given simultaneously or subsequently at the end of the trial or the decision, whatever it is. Interim compensation, the special court grant an interim compensation at any stage after the first information report is filed, either on its own or through an application. Okay, now this compensation will be adjusted at the time of the final compensation which is awarded if the person is acquitted or if the person has been convicted into that particular case. Secondly, now how the recommendation for compensation will be made. The court may recommend the compensation even if the accused is acquitted, not identified, or where the child has suffered the losses due to the offence. Now for example, what kind of loss will a child bear? First of all, there could be a hindrance in his mental state due to which he cannot attend the schools. That would be his educational backdrop. The child would go under various kind of mental traumas and harassment due to this. So this recommendation of compensation is very necessary. Secondly, which factors are necessary for considering the compensation? So the factors which is necessary is that type and severity of abuse. Secondly, the medical treatment cost. Thirdly, the loss of educational opportunity, employment loss, relationship between the children and the offender. Mostly what happens into the POCSO Act is like majorly the offenders are the members of the family, and they do such kind of act because they think that the child is not able to express himself. And at that time it generally happens that this family members take undue advantage of this given situation and land themselves up as an offender under the POCSO Act. However, next is the duration of the abuse. Any resulting pregnancy or sexually transmitted diseases, disability or financial condition of the child, and thirdly, any other relevant factors. Now, second, what could be the payment source? How the government is going to give the compensation to to this victim? So, this compensation is basically given from the victim compensation fund. If that particular fund is not available with any kind of state government or the central government, then they have to make arrangement for this compensation fund from any of the other funds which is available. Secondly, what is the payment guideline? The state government must pay the compensation within 30 days of receiving the court orders. So there is also a timeline which is given, which has to be followed. The compensation has to be given within 30 days. Secondly, what is the additional claim? Now, can they ask for any other additional amount other than the compensation? Yes, they can. The children or their guardians may seek a relief under applicable government rules and schemes. Okay, so in this also we have a good judgment, that is a Birjoy that is Guddu Das versus State of Bengal. In this, the Calcutta High Court has ruled that the special court could grant interim compensation for for immediate relief and rehabilitation independent of any compensation the convict may be ordered to pay. So first what we said that the interim compensation would be half of the portion. But this judgment said that the interim compensation could be different and the other compensation could also be different. Now, what are the important features of the POCSO Act? So, till the moment, whatever we have learned from this act, we got to know this act is about complete protection of the victim child. Take it as its confidentiality or its its gender neutral provisions. Secondly, the mandatory reporting. So this all makes this provision a very stringent provision when it comes to any kind of sexual offences against a children that is below the age of 18 years. First is that confidentiality of the victim's identity. So we said that section 23, under section 23, you are not allowed to reveal the identity of any of the victim under the POCSO Act. Secondly, we have a gender neutral provision. So the POCSO Act treats victim, let it be a man, a boy or a girl, as neutral. So there are no different provision if the victim is girl and there is no different provision if the victim is a boy. Okay? Mandatory reporting. So section 19 to 22 of this act requires a mandatory reporting for a child abuse by those who suspect or are aware of such situation. Not only the parent or a guardian of the victim girl, but also any of the person from the locality who is aware of such sexual offence which is falling under the POCSO Act or any kind of sexual offence which is happening against a child, then he should report that case and the complainant can be any party. Now, what is a skin to skin contact case? So, in Attorney General versus Satish and others, the Supreme Court overturned a ruling requiring skin to skin contact for sexual assault for a conviction under section 8 of the POCSO Act. Now, the court clarified that the sexual intent, not physical contact, is the essential element of offence. Now, what is section 8? Section 8 was a sexual assault. What did the sexual assault case say? That if there is a physical contact, okay, there is a physical contact, but the Supreme Court very clearly said it is not only about the physical contact, but a person's sexual intent. How did he touch that girl? So we have basically two types of touch, that is good touch and bad touch, which is taught to every children in every school. So as per that, after we feel that touch, what kind of feel did you get? So the clear sexual intent should be there to prove a case under section 8 of the POCSO Act. Secondly, now let us see the shortcomings. So certainly the one of the shortcomings, as I said, was the last seen theory, which is completely unreasonable. When it comes, there is a delay in both the incident, that is the last scene of the victim and the offender, and when the act happened, then this consent in sexual activities. अभी क्या हुआ है कि आजकल के सोशल मीडिया के ज़माने में इट इज़ वेरी इजी कि हम लोग जो छोटे छोटे बच्चे हैं दे डू कैरी अ हैंड डिवाइस और अ मोबाइल फ़ोन बिकॉज दैट वाज रिक्वायर्ड ड्यूरिंग द कोविड टाइम्स फॉर द स्टडी पर्पस. But due to the readily available material on OTT platform, or they easily get to see that what is happening around, or they are getting mature very quickly when we take it to the sexual aspect or anything. So this small children tend to get into relationship, and nowadays this relationship between the small children is generally exploited, and the offenders, even if it is a consensual relationship, because in POCSO the consent does not come into picture, then they are arraigned as an offender into this act. Now why are they arraigned? ऐसा हो सकता है कि चौल में उनका झगड़ा हो गया, मम्मी पापा को नहीं पसंद है उनका रिलेशनशिप, इसके वजह से फॉल्स एक्यूजेशन लगा दिए. तो ये जो लोअरिंग ऑफ एज है ना, वो एक बहुत इंपॉर्टेंट क्वेश्चन रह गया था अंडर द पॉक्सो एक्ट. Why? Because of this changing environment or the changing kind of attitude between the children. So now let us take secondly, इसके वजह से क्या होता था, फॉल्स कंप्लेंट होता था. तो ये क्या हो गए, शॉर्ट कमिंग्स हो गए, 3 हो गए. लास्ट सीन थियोरी हो गया, लोअरिंग ऑफ द एज लोअरिंग एज करने के लिए हम लोग ने जो डिमांड किया था, जो एज क्राइटेरिया उसके अंदर रखा गया, वो एक उसका शॉर्ट कमिंग है. सेकेंडली है फॉल्स कंप्लेंट. अभी क्या होता है, मदर और फादर में डिस्प्यूट चल रहा है, मैट्रिमोनी का, कस्टडी का सीन है. मम्मी को कस्टडी चाहिए बच्चों की, और मम्मी चाहती कि नहीं, वो बच्चों पप्पा के पास नहीं जाने चाहिए. तो वो क्या करेंगे, पप्पा बुरे हैं, पप्पा ने ये किया, और ऐसे करके उन लोग फॉल्स केसेस लगाते जा रहे हैं, जिसके वजह ये ब्यूटीफुल पॉक्सो एक्ट का बहुत अनड्यू एडवांटेज लिया जा रहा है. ये उसके शॉर्ट कमिंग्स हो गए. ठीक है, तो अभी हम रिसेंट जुडिशियल डेवलपमेंट्स की बात करेंगे. 2022 में हम लोग ने एक सिग्निफिकेंट चेंज देखा पॉक्सो एक्ट में, जिसके अंदर उन लोग ने क्या किया, जो प्रोविजंस थे उनको और स्ट्रिंजेंट बनाया गया, जजमेंट्स आए जिसकी वजह से वो और स्ट्रिंजेंट बन गए. सेकेंडली, अब ये लोअरिंग ऑफ एज वाला जो कंसेंट है, उसके जो फैक्टर है उसको कंसिडर किया था कर्नाटका हाई कोर्ट ने, मद्रास हाई कोर्ट ने, और रिसेंटली 2015 में बॉम्बे हाई कोर्ट ने. तो मद्रास हाई कोर्ट का हम लोग सबसे पहले देखेंगे. मद्रास हाई कोर्ट ने एक एंटिसिपेशन में एक्सप्रेस्ड एन एंटिसिपेशन फॉर लेजिस्लेटिव चेंजेस टू लोअर द एज ऑफ द consent, emphasizing the need for more nuanced understanding of young relationship. तो यही प्रॉब्लम हो रहा है कि a boy aged of 25, he is in consensual relationship with a girl aged 17 years, and if there is any kind of family disputes, वो लड़की अभी 18 की हो गई है, लड़का कितने का है अभी हम पकड़ लेते हैं, ये 17 का था, ये 25 का था, अभी ये 26 का हो गया, लड़की अभी 18 क्रॉस कर चुकी है. ठीक है, बट अभी क्या हो गया है कि अभी पेरेंट्स को एग्रीड नहीं है इनका शादी, और इसके लिए लोग क्या बोल रहे हैं कि आप एक काम कर दो, लड़के के ऊपर पॉक्सो लगा दो. एक्ट कभी हुआ है, जब वो 17 की थी तभी, तो पॉक्सो इज एप्लीकेबल, और उसी वजह से ये पॉक्सो एक्ट जो है उसको रैम्पेंटली मिसयूज़ किया जा रहा है, और उसी प्रॉब्लम को कंसिडर किया है मद्रास हाई कोर्ट ने उसके जजमेंट में. सेकेंडली, कर्नाटका हाई कोर्ट ने वही बोला है, नोटेड द प्रिविलेंस ऑफ द केसेस इन्वॉल्विंग यंग कपल्स मैरिंग एंड हैविंग सेक्शुअल रिलेशनशिप, अर्जिंग द लॉ कमीशन टू रीअसेस द करंट एज क्राइटेरिया. तो इसके अंदर इन लोग ने क्या बोला, जस्ट टू मेक इट क्लियर कि तुम लोग ने 18 ईयर्स का कंसेंट रखा है ना, ब्रेक इट डाउन एज पर योर कंसेंट, क्योंकि आजकल के बच्चों को बहुत सारी चीज़ें पता है ऑलरेडी, एंड उसके वजह से उन लोग ये कंसेंशुअल रिलेशनशिप में आ रहे हैं. बाय कंसेंट दे आर कमिंग इनटू दिस फिजिकल रिलेशनशिप, एंड इफ जस्ट बिकॉज सम ऑफ द क्वारल बिटवीन देम, अगर आप वो पर्टिकुलर इंसान को रॉन्गफुली अरेंज कर रहे हो, देन इट इज़ अ मिसयूज ऑफ दैट ऑफ हिज फंडामेंटल राइट्स. उसके फंडामेंटल राइट्स को भी ब्रीच हो रहा है, उसका राइट टू लाइफ भी ब्रीच हो रहा है. सेकेंडली, बॉम्बे हाई कोर्ट का रिसेंट था, and this is a very good thing because this is between not only between a personal law and the POCSO Act, but how there is an interrelation between all different kinds of law which are into force in our country. So the Bombay High Court has called for India to reevaluate its age of consent law, noting that many countries have lowered the age of consensual relationship. So Justice Bharti Dangre ruling highlighted that the act leads to a criminal charges against individual in consensual relationship, as seen in case where 25-year-old man was convicted of raping a 17-year-old girl who claimed their relationship was consensual under the Muslim law. The court found the evidence of consensual intercourse and overturned the conviction, emphasizing the need to distinguish between the age of consent and age of marriage. Justice Dangre criticized the current law for failing to recognize the minor's agency, resulting in unjust criminalization. While affirming the importance of protecting the children from exploitation, the court argued that such protection should allow the adolescents to explore their rights without the fear of prosecution, stressing that the criminalization of consensual relationship necessarily burdens the judicial and child protection systems. Up now beautifully we will explain that how Muslim marriages and POCSO cases are related to each other. Under the Muslim personal law, there is no such criteria that after the age of 18 only the girl could get married to a boy. There is no such criteria. Hence, how this POCSO Act will impact on this Muslim law, that we are going to learn. So, the another contentious issues arose regarding the conflict between the POCSO and the Muslim personal law, which allows a girl aged 15 to marry. So, the Kerala High Court ruled that the marriage under the Muslim personal law does not exempt a husband from liability under the POCSO Act if wife is a minor. पहले कोर्ट ने सीधे बोल दिया कि नहीं, वो अगर माइनर है इसका मतलब ये नहीं कि आप पॉक्सो से हट जाओगे. अगर उसके ऊपर सेक्सुअल अब्यूज हुआ है एंड इफ शी कम्स एंड रिपोर्ट्स इट, देन यू विल बी हेल्ड कल्पेबल अंडर द पॉक्सो एक्ट. हाउएवर, आफ्टर दैट the Karnataka High Court said that but the POCSO Act supersedes the personal law regarding the age of consent. Yet in another case, it acquitted a man who had sexual relationship with the Muslim wife, indicating the ongoing legal confusion. So there is still a legal confusion that whether if a girl who has been married to a person under a Muslim personal law, if she is below the age of 18 years, then if that man will be convicted or acquitted under the POCSO Act, or will he be held liable for the offences under the POCSO Act. Now secondly, now Supreme Court has taken its involvement into this particular question, and it has said that the Supreme Court has agreed to examine whether the Muslim girl who has attained the age of 15 can contract marriage, raising important question about child right versus personal law. However, there is no specific judgment as to whether the court has given a clear direction that he cannot be prosecuted or he will be prosecuted. So still there is a confusion when it comes to Muslim personal law, because there is no age criteria for marriage that a girl above the 18 years can only marry, but the girl below the 18 years can also marry under the Muslim personal law, and which raises a question under the POCSO Act still today. Next, we will come to how there are various developments which have taken place into the POCSO Act to make it more stringent by various courts in India. So first of all, we will cite a beautiful thing which has been said or directed by our Chief Justice of India, which is D.Y. Chandrachud. He has emphasized that importance of encouraging the families to report a child sexual abuse even when the perpetrator is a family member. He noted that the cultural stigma often create a culture of silence around this issue. Now, as I told you, one case under which a husband and wife were involved into a sexual harassment of a child, and simultaneously got to know the victim who was there was their niece. And the family kept silent about it because it would lead to a bad name of their complete family or their complete family line in the society. Hence, they never report such kind of cases, and the child is also asked to keep quiet about such cases, which certainly damages the child's mental health and leads to unreporting of such heinous offences in the society. So our Chief Justice of India has taken a proper cognizance of the cases, and he said that you should report the cases. And it is fairly good that many cases under which the offender is a family member is coming into the picture these days. Next, we have the balancing the family honor and the child safety. Now, the CGI in his judgment also asserted that the family honor should not take a precedence over the child's best interest, advocating for systematic change that encourage reporting and support for victims. Next is the judicial backlog. उसका solution क्या है? कोर्ट में इतने सारे केसेस पड़े हैं पॉक्सो के, उसको हम लोग कैसे फटाफट, जैसे जो प्रोविज़न दिया गया है एक्ट में, उसको कैसे फटाफट डिस्पोज ऑफ करें. तो उसके लिए सुप्रीम कोर्ट जस्टिस B.V. Nagnathan has pointed out that merely establishing a fast-track court to try the POCSO cases will not suffice unless accompanied by appointment of more judges and adequate training for law enforcement personnel. क्या करना चाहिए है? सबसे पहले जुडिशरी में लोग लाओ. आज अगर हम लोग देखने जाएं इंडिया में इतने कम मजिस्ट्रेट कोर्ट्स है जो 164 के स्टेटमेंट रिकॉर्ड कर रहे हैं ऑफ द विक्टिम. There should be increase in the number of the magistrates, and that too trained magistrate who specifically focuses on this POCSO Act and look at its disposal at the earliest. So the increase in the number of judicial officers is really required when it comes to disposal of such of offences under such special act. Next, we have the focus on rehabilitation. It is not that we only give compensation to the victims, but their rehabilitation under this act is also necessary, because during this stage of the act or the offense which is committed on her is not only about her physical damage but also about the mental trauma she has suffered. So the rehabilitation of the victim is another major question which comes into this picture. Secondly, there should be a positive development. In 2012, a child-friendly special court for POCSO case was inaugurated in Kerala, marking a step in the right direction. This initiative aligns with the spirit of the act, fostering an environment conducive to justice for child victim. So special courts जैसे केरला ने एस्टैब्लिश किए हैं वैसे ही बाकी स्टेट्स में भी आना चाहिए, ताकि जो भी विक्टिम्स है पॉक्सो के दे कैन कम अहेड एंड दे कैन स्पीक their word very clearly and without any fear. Lastly, we have that every coin, as I said, has its two sides. So we also have some false cases of POCSO Act which are coming into the pictures. And what are these false cases about? So as I told you, that there is a small locality in which there is a water dispute, and there is some kind of personal grudge that you want to take against that person. So what these people do, they make a false accusation of sexual abuse or sexual harassment against the opposite party, and this way they file a false case against him. Now there is a high increase in these false cases in our particular state. What I am currently practicing into, I have seen that such false cases have been increased on day-to-day basis. Secondly, there could be a false case in which two young people are in a consensual relationship and there is a family dispute, and that's why they have arranged that particular boy into this POCSO Act. Secondly, there could be a marital dispute between the mother and father with regards to the custody. That's why they have made the father a false accused under the POCSO Act. Secondly, the inherent cases, in that also they are filing many of the false POCSO cases, which is the abuse of this beautiful provision. Now we will see at some of the judgments which are passed by Honorable Supreme Court and other courts. So first we have N. Chandra Mohan versus State. Here the wife had filed a complaint against the husband stating that the sexual assault was committed by him against their daughter. The false accusations were made to get a full custody of the children. Then the elder daughter, who was the victim's sister, had stated that all these allegations are false and it was only made merely for the purpose of the custody. Next we have Suhara and others versus Mohammad Jalal. It was observed that it has been a significant amount of increase in the number of fictitious cases which were filed against the father under the POCSO Act. This kind of fictitious cases must be handled with care, is what the court has directed us, with atmosphere and care and caution by the family courts in India, especially when the custody related matters are going on before the family courts. Children are being increasingly used as a means to harass and intimidate the other party in the justice system. Now the High Court of Delhi has expressed the disapproval of the same in the judgment of Suhara and others versus Mohammad Jalal, observing that this tendency is growing and making serious allegations in order to just win the matrimonial cases. Now we can see that this could be an ego of a person or anything else, but arranging a person as accused in such a serious crime is utter misuse of this judiciary system or this judicial system. Now, a similar instance took place before Kerala High Court when a wife accused her husband of sexually assaulting their son in order to restrict and prevent him from meeting and having a kind of interaction with his child. The husband and wife were in process of dissolution of their marriage. In the family court, the wife alleged that the husband had shown a nude photographs to their son and touched his private parts during the court allowed interaction. Upon revisiting the history of the family court proceedings between the party, it was found that there were no such issues reported in the past during the court ordered interactions between the child and the father. No such observation was also made by the counselor which was appointed by the family court. So the Justice Jihad Rahman, while granting a bail to the accused father, had highlighted the significance of mentioning a caution in such kind of cases. So in that judgment itself, the court has observed that the growing tendency in recent years to foist a false crime against the biological father, alleging that the recent year to foist a false crime against the biological father, alleging the sexual abuse of his own child, misusing the provision of POCSO Act when the serious fight for custody is pending for resolution before the family courts. Now, let us learn about what impact the Bharatiya Nyaya Sanhita, the Bharatiya Saksha Adhiniyam has made on prevention of children from Sexual Offences Act 2012. Now, when the Bharatiya Nagariya Sanhita or the Bharatiya Saksha Adhiniyam had came into force in July 2023, which is like for the FIR which are filed after 1st July 2024. So in that they have made some beautiful provisions under which a video conferences could be conducted. So specifically the BNSS, that is Bharatiya Nagrik Suraksha Sanhita, aims to streamline the judicial process and enhance the efficiency of trial involving the children and the women. Now Bharatiya Sakshi Adhiniyam provides a better evidences which could be recorded and which could be certainly beneficial in cases of the POCSO Act. Next we come to the conclusion of my topic. Now a balance must be struck. Basically there should be a balance between the from protecting the children from Sexual Offences Act and by reducing the number of false cases which are filed. Secondly, it is crucial to carefully consider the interest of both, that is the children and the accused, that is a false accusation as well as the emotional and mental distress which the children has going through, which is causing a potential harm to the children. Secondly, such accusations can also cause an adverse impact on the accused's career and reputation even if proven innocent, leading to loss of both the trust in the justice system and undermining the acts of purpose. While the POCSO Act aims to protect the minors from the sexual exploitation, it is sometimes exploited in the child custody and divorce proceedings, resulting in the false cases. Society must recognize the seriousness of POCSO allegation and stricter penalties should be imposed to deter the misuse. So, as I said that as there is a punishment for the POCSO, for the offenders under the POCSO Act, there should be also some kind of penalty which is imposed on the people who misuses this act by putting a false accusation on a person. So, I would also cite one small case in front of you. Many a times it does happen that the office quarrels also results into involving or arranging a person into a POCSO Act. But we should realize on the grounds of the humanity that such act could not only render the person from to go through the mental abuse or the physical abuse, but could also cost his career and entire life. So be very cautious when you file such kind of cases and help the law to make a proper use of all kinds of provision that they have made. POCSO is a very beautiful act only if we implement it in the way it is meant to be implemented. Thank you.
Thank you, Preshita. It was nice hearing you because this POCSO is, even though it has been a recent act, still there are a lot of controversies in that act. But it was nice hearing, and this act again is going to be a very important act because this is the way we need to protect our kids from all those sexual abuses. So thank you very much. This is a small token from Hammurabi to you.